Good morning, everyone, and welcome to the 2024 License Code and Rules update. My name is Matt Holder, and I'm the Education Director here at the Real Estate Commission. And today we're going to be going over the 2024 License Code and Rule update, which goes into effect on November 1st of 2024. This has been probably the most substantial update to the code and rules, probably in the history of the commission. And so as we get started today, we always like to start with the purpose of the Real Estate Commission, why we even exist. And really, that is to safeguard public interest. We are first and foremost a consumer protection agency, and having to do with real estate, of course. And we also provide quality services by assisting and providing resources like these webinars that you're watching today. And then, of course, encouraging and requiring high standards of knowledge and ethical practices of licensees, and investigating and sanctioning licensed activities, and through the prosecution of any unlicensed person who violates the Oklahoma License Code and Rules. So as we go through all of the rule changes today, just know that that is the purpose of the Real Estate Commission. And as a licensee, you are probably subject to some other regulatory bodies in real estate. And you'll notice on the screen here, let me see, this is new technology, so I'm learning, feel like a weatherman kind of. Okay, so at the bottom of the triangle or the pyramid here, you see the Real Estate Commission, OREC. And that again is the state government agency regulating the real estate industry. And then all of the tiers above that are different regulatory bodies that you're subject to, or you may be subject to. For example, the National Association of Realtors. They issue the Code of Ethics that we have about 14,000 of you that are members of the National Association of Realtors. And then they have the State Association. And then you have your local association. There's 17 local associations across the state. Then, of course, you have your MLS and then your broker or your brokerage. Now, the reason that we like to show this chart is because as we go through the rule changes today, you always want to make sure to check with your broker, because your broker may have higher standards and standards of operation for you at their brokerage. So if it seems like maybe there's something that we're presenting today, you're like, oh, well, that's not how we do it at our brokerage. Well, just know that the Real Estate Commission is the minimum standard for real estate practice in Oklahoma, and your broker may have other policies and procedures that you need to know and you need to follow. So your broker has the highest level of standard, and so we always want to remind all of our licensees to check with your broker if you do have questions regarding any of these rule changes and how they impact your practice at your brokerage. So no matter what, everybody has to follow, everyone with a real estate license, and then of course all real estate licensees have to follow that Real Estate Commission license code and rules. So what we're going to be going over today is first the Real Estate Commission, some operational updates that we made to the code and rules. We'll go over some licensing requirements, licensee operations, which just means you as a licensee, whether that means you're a sales associate, you're a broker associate, or maybe you are a broker, branch broker, managing broker, and then also some education updates. I know there's a lot of questions around continuing education, so we're going to go over that. And then we also clarified a lot of rules around the investigations process, so we're going to go over all of those rules as well. Now, as we get started here with the OREC operations update, the first thing that we're going to go through are some administrative fees that changed, update to contract forms committee, and then some updated definitions. So these slides are laid out in such a way that I didn't put the exact rule on each slide because I don't want to read to you the exact way that it's written. So if you do want to go and cite the actual rule, you'll see it in the upper corner of the PowerPoint. There, it actually cites the rule that is changed or that is updated. So if you do want to follow along on the rules, you can look at the specific citation up in the corner there, and of course download our mobile app for the easiest way to access the code and rules. So the first change here is the Open Records Act, a fee increase here, or a fee change. We actually decreased one and lowered another one. As a government agency, your information, your information that you have in the license portal, is a public record. So sometimes people call into the Real Estate Commission and they request an extract, a data extract for who has a real estate license in the state of Oklahoma and what is their contact information. And so that is available obviously for a fee. And that fee is $50. So we increased that fee by $10. And then we also have another record that people can request. And oftentimes brokers request this, and that's examinee data extract, which just means anybody that has sat for a real estate exam in the state, and that fee has decreased by $25. So the slides, again, are laid out by just a simple way that the rule has changed, who is impacted, and then how that will impact who it's impacting. So we tried to lay this out pretty simple, and so we can get through most all of the changes. I will skip past some of the changes on this webinar. For our educators, there was another webinar, so make sure that you look out for your email. If you are an educator approved through the Real Estate Commission, you will have received the recording for the education-specific notes on the rule changes. So my clicker is not wanting to work very well. So the next rule that we removed is the returned check fee, and this impacts all licensees. And really the reason why we did this is because most transactions with the Real Estate Commission are now done via the license portal. So if you log into your license portal, you can, for example, renew your license 24 hours a day, 7 days a week, and most of the other fees that we would be collecting are all done through that license portal. Otherwise, it's some disciplinary action fees or fines that are imposed for violating the license code and rules, and sometimes people pay those by check. But we felt like this was something that was a common sense change to make to the code and rules, removing this returned check fee. Next, we had a fee change for certification of license history and letters of good standing. This really applies to anyone that's requesting a license history or a letter of good standing, and that fee increased from $15 to $25. You'll see a need for a certification of license history when moving from Oklahoma to another jurisdiction, or if you're in another jurisdiction already and you need a license history or a letter of good standing for another jurisdiction license. So another state, if you are licensed in another state, sometimes they will request a certified copy of your license history and a letter of good standing. So we increased that fee by $10 to $25. Another exciting change that we have is that we expanded the contract forms committee by 2 members. So now the Real Estate Commission appoints a total of 5 members to that committee. We have about 80 contracts and forms that the Real Estate Commission produces. They are, again, for free and optional use. And we also just made another exciting announcement, or we will be making another exciting announcement. By the time you're seeing this, the announcement will be made that those forms are now behind your license portal. So you'll access the forms on your license portal. So we made this change to add additional voices and additional expertise to the committee, and really just to be able to improve the forms even further. We made a lot of changes, and you'll see that in the upcoming newsletter that's probably out by now by the time you're seeing this. And that's probably 50 pages of changes that happened to the contracts. And these are expert volunteers from around the state. These are brokers that are doing incredible business. And members from the Oklahoma Association of Realtors, the Oklahoma Bar Association, and then, of course, here at the Real Estate Commission. So the work that this committee does is really invaluable to the industry, and we always like to thank all of the members of that committee. So we're excited to add 2 more seats there and get some more voices a part of the conversation for improving. Simple definition modifications here in the Code and Rules book. You'll see later at the end of the presentation 3 slides with a bunch of references throughout the Code and Rules. we edited anytime it said branch office broker to now just read branch broker for continuity. We refer to branch brokers as branch brokers instead of branch office broker. So we made that change all throughout the Code and Rules book. And then we added limited liability companies to the definition of entity and firm. LLCs are one of the most common entity types that we see here at the Real Estate Commission. So we wanted to add that to the definition of entity and firm. Just to make it make a little bit more sense as you're going through that license code and rule book. Next up, we have licensing requirements. So we're going to talk about applications and renewals, licensing procedures, and then non-resident licensing. So first, we eliminated bankruptcy from the civil matters that applicants must report to the commission when making application for a real estate license. So the previous Code and Rule book stated that you had to disclose that to the Real Estate Commission, and we really don't issue a license or not issue a license, rather, whether or not you've had a bankruptcy and used that legal proceeding through the courts. So we did remove that requirement for disclosure when you are making application to the Real Estate Commission. So that's no longer required. Next, we increased the time period an application may be approved from 90 days to 1 year. And this is referenced a few times throughout the code and rules for different licenses. So we updated, you'll see at the top corner of the screen there, additional places that it was referenced, including non-resident licensing. And we did this, this affects any applicants that are seeking a provisional sales associate license, as well as any current licensee that wishes to upgrade their license to, if, for example, a sales associate moving to a broker. And so that affects everybody. So applications are now valid for 1 year, and that is consistent with the time period of a passing exam score. So if, life shows up and you've applied, previous to this change, if it passed that 90-day mark, then you would have to reapply, pay another application fee. So we wanted to really match those applications with the examination, the validity of a passing examination score. Next, we increased the fee for sole proprietor broker's license, and there's a few reasons that we did this. The fee increased to $400, so this applies to brokers applying for or renewing a sole proprietor broker license. And the reason that we did this is because as a sole proprietor broker, if you are a sole proprietor and you have agents operating under you as a broker, if in the event of death or disability of the sole proprietor broker, all real estate activity has to immediately stop. And that can cause a huge disruption in all of the licensee's businesses. So we wanted to sort of discourage this license type and make it, have that fee increase. So there are other license types that sole proprietors may look at. And if you have other licensees under you, you may connect with our licensing staff and ask the team how they can help you transfer that license to a different license type. Next, we increased the fee we increased the fee for a change in managing partners, and then we removed the group name change fee cap. So this applies to brokers that are operating as a partnership, and that fee increased to $40. Next, this applies to our non-residents. So non-resident licensees must maintain a resident or a registered agent, rather, in Oklahoma. And this is to accept process of service, any notification from the Real Estate Commission. For example, if a complaint is filed and we notify you, of course, you're going to receive an email notification immediately. But written notices that we send, we have to have a registered agent here on the ground. So you want to make sure that if you are a non-resident, you have a registered agent on file with the Secretary of State, and that it is up to date. So you must establish and maintain a registered agent in Oklahoma to accept service of process. Next, we increased non-resident experience standards. So previous rule was that you had to have 2 years out of the last 5 years active in another jurisdiction, and now that rule has changed to 2 out of the previous 3 years. So in order to qualify for an exam waiver, you have to have been active for 2 out of the previous 3 years and complete 6 hours of contracts and forms, 1 hour of Broker Relationships Act, and 1 hour of Code and Rules. So you'll see that 6-hour contract and forms, that is a part of the continuing education increase. It used to be 1 hour of contract and forms, and now it is 6 hours of contracts and forms. So through all licensing, we did update any reference from that required 1 hour to now it is 6 hours. Next, we increased non-resident experience standards. Again, non-resident applicants active for less than 2 years. Sorry, I had to make sure I was on the right slide there. Non-resident applicants who are active for less than 2 years in another jurisdiction. In order to be exempt from the 90-hour pre-license course, the applicant, in addition to everything that I mentioned on the previous slide, they also have to pass the appropriate examination, and they still have to do those continuing education hours, 6 hours of contracts and forms, 1 hour of broker relationships, and 1 hour of code and rules. This applies to non-resident applicants who are inactive in another jurisdiction. So we covered active. The first one we covered was active, 2 years, minimum of 2 years active experience in another jurisdiction out of the last 3. Then the previous slide was less than 2 years experience. And then now this slide is regarding non-resident applicants inactive in another jurisdiction. So you may apply for a provisional sales associate license by submitting proof of meeting the education requirements and also passing the appropriate exam, and of course completing the 6 hours in contracts, 1 hour in broker relationships, and 1 hour of code and rules. Moving on to the education update, this is much anticipated. Continuing education hours. Commissioners voted to increase all continuing education hours from 21 hours to 30 hours. Now, this applies to sales associates and broker associates, this breakdown that I'm going over right now. It's 1 hour of Broker Relationships Act, 1 hour of Fair Housing, 1 hour of Code and Rules, 1 hour of Hot Topic, 3 hours of Professional Conduct, and 6 hours of Contracts and Forms. And the remaining 17 hours are available to you to use as elective courses. So any education that you're seeking that is registered and approved with the Real Estate Commission, you can certainly take those electives and have those count as continuing education credit. Now, a quick note on all of our CE requirements moving from 21 hours to 30 hours. That is going to be effective June 1st, 2025. So right now until June 1st, 2025, when you log into your license portal and you go to renew your license, you will be able to renew your license with 21 hours of continuing education credit. Starting June 1st, you will not be able to renew your license without that 30 hours of continuing education credit. This one applies to brokers, again, renewing after June 1st. Brokers are held to a higher standard. They have to take a 15-hour broker in charge course every 3 years as part of their license renewal. They also have to take 6 hours of contracts and forms, and they don't get nearly as many elective courses, so they get 9 electives. But I also really encourage all of our licensees to take that broker in charge course because you can actually do that in lieu of taking the other required courses. So you can meet these same requirements as a sales associate or broker associate. And that broker in charge course really gives you another look and another perspective at all of the responsibility that is on your broker. And it helps you become a better licensee or a better associate for your broker. So if you have never taken a broker in charge course, I promise you, you will get a lot out of it. And we have amazing educators across the state that offer incredible broker in charge courses courses, and I can assure you, you'll probably call your broker afterwards and thank them for all that they do for you. So, and all of the responsibility that they have on their shoulders for you. So for non-residents, again, non-residents, that 6 hours of contracts and forms, the 1 hour of Broker Relationships Act, and 1 hour of Code and Rules, that is required for non-residents as well. And then all non-residents, resident licensees that are exempt from CE in another jurisdiction, you must meet the same CE requirements as a resident licensee in Oklahoma. So the slides that we just went over, if for some reason you are exempt from CE in another jurisdiction here in Oklahoma, you do have to go ahead and meet that 30-hour requirement for CE to include that 6 hours of contracts and forms, 1 hour of broker relationships, and 1 hour of code and rules. Another thing that we did is we increased the education and recovery fund. Part of your license renewal, anytime that you are either getting a license or you are renewing a license, a portion of the total that you are paying at the at checkout is the education and recovery fund fee. There's been a $5 increase for the E&R fund on all licensees, excluding provisional sales associates, which will now contribute $15 to the Education and Recovery Fund. And that Education and Recovery Fund, we're very excited about this because we're going to be able to continue offering not only education to the general public and consumers, but we're really excited about all the education that we are going to be offering all of our licensees and our educators. And so obviously that takes resources, and we are going to be utilizing these funds in some pretty exciting ways to increase services for our education providers and you as a licensee. So very excited about that. Next, we established a license fee to open a real estate school. This is really getting into education providers, so I will sort of skip past some of this so I don't bore you to tears. But previous to the November 1st, 2024 rule change, it did not cost anything to establish a school here in Oklahoma. So across the board, we've increased standards and fees for our education providers. Sometimes they weren't having to pay anything at all. And then there were no renewals on some things. And so we felt as if, and the commissioners felt that if you as a licensee are subject to license fees and renewals, the first entry point, the first experience that a member of the public has when they're sitting in a classroom going through that 90-hour pre-license course, that educator should be held to the same standard, if not higher standard than other licensees. So across the board, we made some changes here to our education providers, instructors, and all of our courses. So schools now will apply and pay a $500 application fee and renew every 36 months at $250. And then for pre-licensed instructors, courses rather, is a $500 course application fee on a 36-month renewal. The instructor will pay a $200 application fee. They are also on a 36-month renewal and a $100 renewal fee. And there are some other requirements there for educators. So moving past education education provider updates. This is one that you all probably appreciate. We clarified in-person and distance education course requirements, and we removed the rule for students seeking post-license education prior to license issuance. So there was a rule that stated that a student should not begin their post-license education until after they have been issued a license and finished that provisional the pre-license for the 90-hour. So educators and students can now utilize a mix of live and in-person instruction and distance education offerings to fulfill course completion requirements. So in the event that you are not able to sit in a classroom full-time for the full instruction period, now you will be able to maybe join in live to that classroom. And we understand live shows up, and the point of this rule is that you are actually getting the instruction time. And so we wanted to make that change as well. Next is we remove the effective date of pre-licensed education requirements, and this was really for our students who are studying to get their Oklahoma real estate license. The effective date and some other dates throughout the code and rules, we remove some unnecessary dates there. Again, here's another implementation date we removed. On to licensee operations. First, we'll go over payment of commission entities, team names and trade names, disclosure requirements, duty to account as a broker, and then, of course, broker operations. So first up is payment of commission entities. So we clearly outline procedures for the payment of commission entities. And now this really applies to all licensees who receive commissions from your broker to your LLC. So a few rules here that we really just clarified. Using your payment of commission entity, you're prohibited from engaging in real estate activities or using the name in any advertising or receiving fees from a source other than your broker, and then also using the same name as a registered team name, trade name, or brokerage. The only people that really should know that LLC even exists is your CPA, your broker, obviously, you, and the real estate commission. And then maybe the title company, that is if your broker gives disbursement authorization so you can be paid at the closing table. But outside of that, your LLC that you receive commissions to for tax purposes should never be advertised to the public. And you should always you have to get your broker's approval to register that payment of commissions entity. So if you have questions on if your payment of commissions entity is set up correctly, or if you even have one on file, please reach out to the real estate commission and make sure that you have that. Get with your broker first and connect with them. And then if there are still questions, reach out to the real estate commission on that. We don't, for people calling in or emailing in for help regarding something like this, it's not like you'll be sent immediately over to investigations for not having something set up correct. If you're working to get into compliance, that's what we care about. So if you have a question on this, please don't hesitate to reach out if you or your broker have a question. And you always want to go to your broker first before coming to the real estate commission. Next is we adjusted the days for the real estate commission to release an associate. So if there is a situation where a broker is refusing to release an associate, the real estate commission will provide an additional email notice, and then after 3 business days of us receiving a written request, we will go ahead and release that associate, and that applies to all licensees. This is a disclosure requirement. Licensees acting under a power of attorney must make a disclosure. So who does this impact? Again, all licensees. So when acting as an owner, purchaser, or direct employee of an owner, you must disclose on all advertising and documents in a transaction that you are licensed. So you want to be sure that if you are acting under a power of attorney, you have to disclose in all advertising and all documents in a transaction your license status. Next, we clarified the rules around the disclosure of beneficial interest. So this impacts all licensees. Disclosure must be done in writing and to all parties, and that is required when you own any interest in any entity providing service to the consumer or to the transaction, or when accepting any compensation in any form for referring any product or service. So if there is any sort of beneficial interest whatsoever, you have to make disclosure. We have a free form available in our contracts and forms that make it very easy for you to make this disclosure. So you want to make sure that you are staying in compliance with this. So if there's if you own any interest in any entity providing service to the transaction or to the consumer themselves, you want to make sure that you have that disclosure of beneficial interest on file prior to making that recommendation. This one is a duty to account for our brokers and certainly all of those that are in property management. So this has to do with deposit and account of escrow funds. So all funds that are required by a landlord, including damage and security deposits, must be held in an escrow account that is maintained in Oklahoma and is federally insured. This comes from the Landlord and Tenant Act, so it has already been a rule. We just clarified it in our rules. So if you are looking in that duty to account section, you will see this now. This has again already been a rule, but all funds that are required by a landlord, including damage and security deposit, you have to have those in an escrow account that is maintained in Oklahoma. We outlined disciplinary action for failure to maintain records. So this applies to brokers. Brokers are required to retain records for 5 years. And if you fail to do that, if a broker fails to do that, OREC may take a disciplinary action for failure to properly retain records. So this becomes very, very important, not only for you as your business, but anytime if you get a complaint filed against you or your brokerage, then those files have to be retained in a legible way. All the documents need to be able to be read. So a lot of people don't have an issue with this, especially now with transaction management software. So those sort of systems, if you're not utilizing those systems, then you want to make sure that you get that in place, and then also make sure that your settings are appropriate for archiving documents within that system. And it'd probably be a good idea to go ahead and create a backup, especially if you're using some sort of third-party document retention system. We clarified the rules regarding team names and trade names. And the commission, when this applies to anyone who desires to establish a team name or a trade name, but when we get applications or requests for establishing a trade name or a team name, sometimes we have to deny those names because either one, they're already registered with us, somebody else has already selected that name, or it's so similar to a name that is already registered that it would confuse the public. So we just outlined and clarified that in the code and rules. So you want to make sure that before you go out and start purchasing marketing materials, paying people to design different things for you over what you may think is a unique name, that you check with the Secretary of State, make sure that that name would be even available. Make sure that you check with your broker, of course, that's your first stop. And then make sure that you check with the Real Estate Commission, because we've had people order thousands of dollars of signs, for example, and then not be able to even use those signs because there was a name that was already registered, and it would confuse the public. So no longer required to return licenses to the commission. This applies to sole proprietor brokers. In the event of death or disability of a sole proprietor broker, all business, like I said earlier, must cease immediately. A family attorney or representative may destroy all the license certificates. And the reason that is because any licensee that's under a sole proprietor broker, there's not a 30-day window like there is with other license types for an entity that gives some time to establish another broker. So, all of the licensees underneath that broker's license don't have their business interrupted immediately. So sole proprietor brokers, we just clarified that in the rule. And I think that this is a duplicate slide, so that's fun. So again, OREC will release an associate within 3 business days following a written request. And then of course we will provide the broker 1 additional email notice. Next, we made some great changes to our investigations process. So first we'll go over the definitions that have been put into the code and rules, complaint procedures, hearing procedures, and duties of those participating in a hearing. So we outlined first a complaint, and that is exactly what you might think it might mean, and that's just a formal allegation of alleged violations of the code on the part of a licensee or any unlicensed person. A formal hearing, this is a trial mechanism employed by the Commission to provide due process to a respondent when the Commission lodges formal charges against a respondent. Hearing examiner means any person appointed by the Commission to oversee the formal charges, and that would be like the judge. And then the respondent, that means any licensee or any unlicensed person or company who is the subject of a complaint. You can think of the respondent as the defendant in a trial, and then the plaintiff is the state of Oklahoma. So who's impacted, any complainant or respondent, and how we just clearly define the terms in the course of an investigation. Next, on complaint procedures, we removed the requirement for a complaint to be notarized. Now you can log into your license portal, or not log into your license portal, excuse me. You can log into the Real Estate Commission's website at orec.ok.gov, and you can submit a complaint on the online portal. So there's no reason that somebody needs to go make a complaint, write a complaint out, and then have it notarized. Now it's can be done 24/7 via the Real Estate Commission's website. Next, we modernized the rule for responding to a complaint, and we did this. Used to, you would have to mail a response in to the Real Estate Commission, and now in 2024 you can actually email a response to a complaint to investigations@orec.ok.gov. And if you are using email, it must include the case number, which will be referenced on the complaint or the written notice of a complaint that you receive, and the name of the party submitting the response, and the subject line should be response to complaint. If no response is filed within 15 days, the respondent is in default and sanctions may be imposed. So it's very, very important that if you do receive a complaint, that you make a response and work with our investigators, because if you don't, then it's sort of like just saying that you're guilty. So make sure that you get a response on file within that 15 days, and certainly with the addition of the investigations email, there's really no reason that you can't get a response filed in an appropriate amount of time. So next, OREC may use any process of service method authorized by state law, and so who this affects is any respondent in a case. So if there is a complaint filed, a process server may serve the respondent and the broker. If we can't reach you for some reason via certified mail at your last known address, then we will get with a process server and go that route. So that is something that has changed in the code and rules. Next, an investigation may continue after the 15-day response period. So really all this means is that we may designate a prosecutor to examine the results of the investigation, subpoena witnesses, take testimony or by deposition, and then compel the production of records relevant, of course, to the investigation. The investigative report, so all of the findings, may be submitted to the Commission. So this affects all parties to an investigation. So upon completing an investigation, if there is any evidence, a written report will be submitted to the Commission, and the Commission shall determine if formal charges should be lodged. They may order a formal hearing, and then of course if a formal hearing is ordered, all parties will receive the report. The Commission may enter into a consent order with respondents or go to formal hearing. So sometimes if there's an investigation, the parties may decide to consent or take a plea. That's another way to look at a consent as a plea. and that affects all parties to an investigation. So respondents, including the broker, will receive a 15 days written notice via process server in the event or by certified mail. I should mention that because it does not say that on that slide. Or by certified mail if there is a consent. Formal hearing location, request for hearing held virtually. Now with 7 days prior to the hearing, any party may request to have the formal hearing be held virtually. And if there is such a request for a formal hearing to be done virtually, then an email must be sent to the Executive Director of the Real Estate Commission, again, 7 days prior to the hearing or longer. And the subject of that email needs to say request for formal hearing to be virtually, include the case number in the email, the name of the party submitting the response, and then not subject line response to complaint. I apologize. I made these slides, by the way. Well, I won't tell you what time, but that's why it says that they're in the a duplicate subject line. So if no response is filed, that also does not need to go there. So just those top 3 bullet points are applicable here on this slide. I do apologize, but yes, you can now request a formal hearing to be held virtually. So, and that can be done 7 days prior to the hearing date. Hopefully this slide is all correct. Procedures for requesting a postponed hearing. So 7 days prior to a formal hearing, if there's a reason, maybe an emergency, that somebody in a party to the investigation is requesting postponement, it must be in writing and state the reason. It must be mailed or emailed to the Executive Director. If emailed, it needs to say request for postponement in the subject. And then OREC may require official documentation supporting that request. And then, of course, emergency postponement may be granted. And then OREC may impose summary suspension if required within 30 days. Next, pre-hearing conference. So prior to formal hearing, parties can agree to a pre-hearing conference, and it also may be ordered by the Real Estate Commission to actually have a pre-hearing conference. And if that does happen, attendance is mandatory by the prosecuting attorney and respondent or the respondent's counsel. And this is similar to pre-trial proceedings in district court. So we clarified that that provision in the investigations process. Hearings are open to the public. This impacts everybody in an investigation. Except by motion of either party, hearings are now open to the public. And then witnesses may be excluded from the hearing room when they are not testifying. A court reporter will be present, and in the event that you would like to purchase a copy of the court transcript, you can do so with the court reporter. So what happens when there is a formal hearing? This outlines the process. So first, the attorney for the state will present the state's case. The respondent may present evidence or through counsel. And then the complaining party may be a witness for the state. So if a consumer complains on a licensee, that party may be a witness for the state. Testimony by witness limited to matters relevant to the case. And then here are the formal hearing procedures. First, they will recite the statement of charges by the person presiding. They will recite the stipulated facts between the parties, if any, by the person presiding. There'll be an opening statement by the state, an opening statement by the respondent, and then a presentation of the state's case, followed by cross-examination. Respondent's presentation, again, followed by cross-examination, closing arguments by the state, closing arguments by the respondent, and then the person presiding may ask the parties questions. consistent with general trial practices under the Administrative Procedures Act. So that is how a formal hearing goes. And so we clarified some of those points, simplified it, and you'll notice that a lot throughout all of the changes in the code and rules. We wanted to make it as approachable as possible, and so that is a great example there of what was done there. Duty to disclose as part of a formal hearing. Every licensee has to make full disclosure at any formal hearing of any knowledge of any violation of the law or rules of the commission, and no one may refuse to testify except, of course, by law. So what happens if you fail to appear to a formal hearing? Any respondent who fails to appear waives their right to present a defense to the charges, and the commissioners may take disciplinary action. Supervising broker attendance. So this affects the respondents and of course, all brokers. So unless receiving written notice stating otherwise, the supervising broker must attend all formal hearings concerning their associates or their company. Here are all of the formal formatting changes listed out by provision. And so I did not want to go through each one of these because a lot of them are just improving the sentence structure or making such a minor change that does not impact your day-to-day. So this is the first slide. Of course, we will send these out for you to view if you would like. And so there's 3 full slides there. Our educators got to see those and have that as a resource for updating their content, their Oklahoma specific real estate content. Next, a couple of legislative updates. Also, House Bill 2955, that removed the Real Estate Commission from the Oklahoma Sunset Law, which basically means every few years the Real Estate Commission would have to go before the legislature and defend the reason why the Real Estate Commission needs to exist. The lawmakers were so happy with the performance of the Real Estate Commission, they went ahead and removed the Real Estate Commission from that sunset law. So we are a permanent agency, and I believe next year in 2025 we're about 100 years old. So at 100 years old you can become permanent. So we're very excited about that. Senate Bill 1920, this amends the Broker Relationships Act to add a disclosure requirement regarding compensation and fees on each transaction. And now this will need to be communicated in writing at the time of execution of an agreement. And you must include a time frame for which the compensation agreement is valid, and it cannot exceed 1 year. And the default time is 60 days if left blank. So what that means is that you cannot sign a listing agreement or a buyer-broker agreement or a contract for longer than 1 year. So you want to make sure that you have that in mind as you are completing contracts. Legislative updates, Senate Bill 927, Senate Bill 927. This simplifies and clarifies licensable activities. We added a definition of transaction for licensure experience that's now required to be a completed transaction. We provided a definition for publicly market, the power to issue cease and desist orders. And so this really affects unlicensed and predatory activity. We clarified that disclosures must be done in writing, added violations for licensees placing predatory liens on property for the purpose of collecting commissions, of course, other than recording a judgment lien. Failure to respond to the commission within 15 days after receiving written notice of a complaint or an investigation, and then soliciting, selling, or offering for sale real property by means of a deceptive practice. And so those are now violations of the code and rules. And then we increased the unlicensed activity violation maximum fine to $5,000. So if there are bad actors in the marketplace that are not licensed, that are doing licensable activities, now that maximum fine is $5,000. And then, of course, we made some updates to the Education and Recovery Fund. So educational expense language to expand expenses for the advancement of real estate education here in our state. And then obviously you have been receiving the newsletters, and we're very excited again about some projects that we're working on regarding education. So stay tuned on the newsletters for that. Our next Real Estate Commission meeting is December 11th. If you are not watching this live, but you're watching this as a recording, this may be already past December 11th, but if it's not, we do invite you to come and join the Real Estate Commission at our next meeting. If you can't make it here, I know we've got 77 counties across the state, kind of a long drive up here to the city, so you can always join our commission meetings on Facebook Live. You can also receive continuing education credit for attending live. You can make public comment through Facebook Live as well. And I think we've got like 400 or 500 people on our last commission meeting that we streamed live. And then of course we love when licensees and members of the public come join us here at the Real Estate Commission. It's right here in this room. So come and join us and hear all the great things that we're doing here at the Real Estate Commission. If you haven't already, scan the QR code on the screen and download our mobile app. The QR code closest to me, kind of getting used to this, is for iPhone, and then the one furthest away from me is for Android. So if you do not have the Real Estate Commission's mobile app, this is a great resource. You can access the license code and rules. You can access the public registry. So when you're filling out those contracts, you can find license numbers very, very easily. And then, of course, we have a resource library and a video library on there as well that has a bunch of checklists and an expanding video library for all of our licensees to utilize. So next we have... It would be great when this clicker decides to be nice to me. Okay, now you can scan the QR code to receive continuing education credit. It's a very, very simple form that you can go on, and congratulations for meeting your 1 hour of required continuing education credit. If you want a copy of the slides that we went over today, those will be available on our website as well. And thank you very much for joining us today. And if you asked any questions in the chat, we will get to those. And if we need to create a frequently asked resource guide, we will. But again, thank you all for joining us today. I will leave this up on the screen so you have plenty of time to get that scanned. So join us at our next commission meeting and look out for the newsletter for upcoming events and offerings from the Real Estate Commission.